Oh. All right, y'all. This is like first of all, can y'all hear me? Can someone tell me did they hear me? Did they hear me? Did they hear me? Did they hear me? Do you hear me? It's the first thing I need to know before I even start. Hello, Miss Ann. Do you hear me? Here we go. Here we go. Hear me. Hope so. All right. That's all I need. Okay, so I'm trying to get my schedule together so I can get on here consistently because I am the media and I have to combat majority of everything that's going on right now. I'm getting beat up because of the Obama Center and the uncomfortable truth about it, But it's just like some people when it comes to the pastor of the church and people in your family that are secretly touching you and molesting you, and you keep it under wraps and don't tell or anything like that. And then when these people think that this person is such a great person and everybody loves them and they're so honorable and righteous, and the whole time they're not, and they could be professors, they could be judges, they are. They're judges, they're professors, they're head of departments, they're politicians, they're teachers, they're union organizers, and it's getting out of control. It's getting out of control. However, we I asked for Donald Trump to 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 bring the Department of Justice to this city because of my case. However, and I always revert back to my case because uh, if it wasn't for my mom fighting and then me stepping into it, I wouldn't have seen how bad it is out here. And the reason why at this day and age, we do not have generational wealth and we're losing everything. So, um, this story came to me because I had a Father's Day event that fortunately it rained today, but next year it'll be our second annual shout out to Apostle Sandy and Chain Breakers and for just making it happen. Matter of fact, God is amazing because we have all the things to set up for everything. Shout out to Ramona um, for making sure that we had our tents and stuff for last year. So we have everything, generators and stuff. But for some reason, I didn't have my fob to get into the office, so I couldn't get all the stuff. But I'm glad that we couldn't because it ended up getting rained on. But we did run out of food. Some people did come, but this particular king came, um, and his story is basically what my mother has been fighting before I got here, and um, they're doing it to him as well. They don't. The city of Chicago, the state of Illinois, Cook County are SBK. They're small business killers, and they will do whatever to run you out of town, run you out of business, take whatever they want to take. They it's real estate theft. All of the real estate agents, mortgage brokers, developers are all in on it because it's unlimited TIF money, and the TIF money needs to be uh, investigated, but also um, gentrification. They brought a whole new group of people over here. And these are their new working class, and they basically don't care about us taking kids. Yeah, that's a whole nother situation. So I'm going to actually get on that starting next week. But in particular with particularly this one is because his court case is tomorrow, and they're basically trying to unlawfully evict him from a building that he purchased $475,000 cash. We're going to start right there. He broke down it all for me. And this is something that I really do need help with because it helps me when it comes to getting the story out there. My story is out there. I know it by heart, stuff because it happened to me. What I need from you guys is when you guys want me to showcase your story and stuff, I can get the pictures and stuff. I can get a lot of more information, when it comes to the politician side, the Cook County Commissioner side, tie it in with these judges, find the pattern and things like that. Or if you guys know the pattern, it helps me link my pattern because at the end of the day, Trump needs to come here because we need the feds here. We need the FBI here. We need ATF here. We need DEI here. I want to show them the pattern of RICO. We are dealing with RICO. Okay. It's Operation Grey Lord, but it's Operation Grey Lord on steroids. Maybe a lot of I want to let you guys know what a RICO is because I don't explain what RICOs are. I think I am going to start talking about. I'm going to start going down there to that mic and start off what RICO is because I want them to understand, and I want it on. I want it on public record because I think everybody. I mean, I've said it, but I haven't said it on the mic. I'm showing, telling y'all the scams, showing us stuff, but I'm not giving you that. But so a RICO case is a federal prosecution or civil lawsuit brought under the Racketeer Influence and Corrupt Organizations Act, a law designed to dismantle organized criminal operation rather than punish individual crimes one at a time. Congress enacted RICO in 1970 as part of the Organized Crime Control Act, giving prosecutors the ability to charge everyone involved in an ongoing criminal enterprise, from the top boss to low level participants in a single case. Before RICO existed, prosecutors often could not connect high level leaders to street level crimes their organizations carried out. The law shifted the focus from isolated criminal acts to the structure and the operation of the criminal organization itself. So basically, this RICO was for drug dealers. It was meant to be for drug dealers, and and the whole judicial system, the whole machine in Chicago, in Cook County, in all of these different counties, and the state of Illinois, it's a RICO. It is a RICO, and we need to get the people involved. We need to get FBI involved. Um, President Trump, I can't be the only one to call on President Trump to come here. Also, Danielle cannot be the only one to call for President Trump to come here, and Miss Jessica Jackson cannot. We have called, we have sounded the alarm, we have done everything that we've done to the point that his eyes is on Chicago, Cook County, state of Illinois. Miss Jessica, they tried to unlawfully evict Miss Jessica from her own property. The same with this man as well. So let's get into it. Because I mean, it's crazy, and I don't think people really understand. And I'm gonna read the whole thing. Now, this. Get your popcorn, get ready. And I'm standing up. I'm in the kitchen because we ain't got no furniture yet. You understand? So if anybody got a couch, a nice couch, gently used couch, love seats, whatever, please email me at Zoe at ChicagoFlips.red or Lee Zoe 23 at gmail.com. Thank you. Thank you. However, I'm blessed and highly favored that I'm able to be here and give this to you in a safe place, safe environment, great internet, because they're messing with the internet on the south side and west side too. That's another thing. Even though like the Woodlawn area has the best, or Washington Park has the most fiber optics. That's why they trying to take everything over there. So let's see. Okay, because I got some more stuff since we talked, so I'm trying to get all right. Smart. And you know what's great about this guy? That he is smart and understands his case very well. And this is the Tony Cole's story. Let me just make sure I got all. I want to make sure I start right. Yeah, be great, be judge. But you know what? They're gonna have no choice but to do the right thing because these people are about to go to jail. These people about to go. It's a pattern. They don't know no law because honestly, I think they all got their law degree from Four Below. I mean Five Below. Like, I just cannot. These people can't, and then people have normalized that you just can't win in this city, and this is just how it is, and you're just gonna have to just take it. It's just crazy to me. All right. Let me so I'm gonna leave her up here because I think that she just needs to be here. All right. The full record. 1205 North Milwaukee Avenue. Tony Cole is a pro se litigant. Shout out to Tony because these judges these lawyers either don't know the law or they're scared to practice the law because they got families and stuff. I mean, you already know how this city is. In April 2018, Tony Cole entered into a lease-to-purchase agreement with Jin Hui Lee for the property located at 1205 North Milwaukee Avenue, Chicago, Illinois 60642. a mixed-use building consisting of a commercial first floor and basement and a residential second floor. Cole had negotiated a path to ownership, agreeing to pay $20,350 prepaid deposit, a $3,600 move-in fee deposit, and monthly payments of $2,150 to be applied toward the mortgage, taxes, and property upkeep within the with the ultimate intent purchase with the ultimate intent of purchasing the property for $475,000. Real estate agent Jin Hee Yang was a central figure in the transaction from the outset. Yang was aware that Jin Lee had sold or agreed to sell the property to Tony Cole for $475,000. Rather than facilitating a clean transfer, Yang instead introduced Jin Lee to attorney David Yanoff, a Chicago attorney who would go on to become one of Cole's chief legal adversaries. This introduction would prove to be one of the most consequential acts in the entire chain of events that followed. Yang's firm was also affiliated with ASPEC Resolutions LLC as an entity later tied to Joseph Faulkner, the man who would eventually claim to have purchased the property and orchestrate a campaign to evict Cole. Cole made payments faithfully and maintained the property. Jin Lee, by his own later sworn admissions, never executed a formal written notice of termination, never refunded the $350 or $3,600 deposits, and never provided an accounting of payments towards taxes or a written itemized statement of any alleged deposit deductions. The agreement was real, the payments were real, and Cole's equitable interest in the property was real. Part 2. The eviction case. Jin Lee files. 2022. On June 30th, 2022, Jin Hui Lee, represented by attorney David Yanoff, filed the first eviction case against Tony Cole, case number 2021 1709496. The case was captioned Jin H. Lee versus Tony Cole and was filed in the Circuit Court of Cook County Municipal Department, 1st Municipal District. Cole contested the eviction. The matter proceeded through the court system and was assigned to Judge Sandra Denmark. Throughout the proceedings, Cole fought with the benefit of counsel. Jin Hee Yang, the real estate agent who had both discovered that Lee had a deal with Cole for $475,000 and introduced Lee to Yanoff, made a notable appearance at the first eviction trial, demonstrating that the network around the Lee was actively tracking the proceedings. Jin Lee own later sworn Rule 216 admissions would confirm that the eviction was filed without prior written notice to cure any alleged breach of the lease, a procedural defect that struck at the very legitimacy of the case. Despite the defect, the case proceeded to a conclusion on March 2023. Judge Denmark dismissed the case with prejudice. A dismissal with prejudice operates as a final adjudication on the merits. Jin Lee lost. He could not refile the same claim. Yes, with prejudice, with prejudice, with prejudice. Can't bring it back up now. You can appeal it, but you can't refile that same case. Matter of fact, I'm dealing with that right now in federal court with the first case I filed. I filed against Rosanna Rodriguez Sanchez, Alvin Starks, some more people, but of course, it got. I never received any notices or anything like that because you know how they hack and do those things. And the judge was he put it out there, failure to state a claim, which was crazy because the claim was in there, but that's the MO, failure to state a claim. But also I don't know if it's them or it's their clerks that's doing it too. That's a whole nother story. It was failure to state a claim, and but it allowed me some time to get it together. But I never received any notice, so I didn't know that it was dismissed with prejudice. So then, when I got banned again, I went and filed it. I refiled the case, but I added the extra stuff on it. But I started with the pattern, and this judge, this uh, lawyer on their side, Bradley Wilson, who's all my he's my attorney on all of them. Anything that we do, my mother do, he do. He's the out of all the attorneys that they have that we're paying for. They always give me Bradley Wilson. But anyway, Bradley Wilson. Um. So yeah, right now I'm fighting that. Let's go back to this. All right. So part three, the second eviction in the federal foreclosure scheme. 10 days after the first eviction was dismissed with prejudice on March 30th, 2023, Jin Hee Lee and David Yanoff filed a second eviction case against Tony Cole. Case number 2023-17049999. The speed of this refiling 10 days after dismissal with prejudice signaled that the goal was not legitimate landlord-tenant enforcement, but rather a sustained campaign to remove Cole from property which he had a $475,000 purchase agreement. On the same day, March 30th, 2023, an entity called ASPEC Resolutions LLC filed a fraudulent federal foreclosure case against both Jen Lee and Tony Cole. ASPEC resolutions were connected to Joseph Faulkner and affiliated with Jihe Ying. The purpose of this federal case was transparent and targeted to create a federal legal instrument that could be used to strip Cole of his equitable interest in the property. The interest that had been built through years of payments, deposits, and a 2018 lease-to-purchase agreement. Cole was not merely evicted; he was being legally surrounded. The second eviction, Judge Barry Goldberg. The second eviction, case number 2023-17049999, was assigned to Judge Barry Goldberg. What followed was a series of rulings that systematically disadvantaged Cole at every turn. Judge Goldberg repeatedly ruled in rem against Cole, and what appeared to be attempts to force Cole to enter a formal appearance on terms unfavorable to him. Every motion Cole filed in the second eviction case was denied. Cole was denied procedural footing in his own case. The case was set for trial on December 18th, 2023. On that date, the court dismissed the second eviction case in Cole's favor. However, an extraordinary and consequential instruction from the bench, Judge Goldberg told David Yanoff and Jen Lee that if they wish to pursue further eviction proceedings, they should file separate eviction cases against Cole and for the residential unit and for the commercial space. So he gave them legal advice on the bench and basically let them know that's how you gotta do it, baby. In late August 2023, while the second eviction case was still pending, ASPEC Resolutions LLC filed a substitution motion in the federal foreclosure case. The substitution sought to replace ASPEC Resolutions LLC with a new entity called 1205 NP There was one stunning problem. 1205 NP did not exist as of the date the substitution motion was filed. The entity was not created until December 6, 2023, months after the motion seeking to substitute it was filed. A substitute motion for a non-existent entity is a legal, where are we at? Nullity. It was, in effect, a placeholder designed to keep the scheme moving while the real instrument of transfer was being engineered. On January 9th, 2024, the federal foreclosure case filed by ASPEC Resolutions was dismissed with prejudice. The federal instrument designed to strip code of his equitable interests failed. But the scheme did not stop there, it simply changed form. Part 4, the fraudulent transfer, the $10 deed. Woo! It's $10, man. It's a trigger word at this point. $10. All right. On November 9th, 2023, Tony Cole filed a breach of contract lawsuit against Jen Lee in the Circuit Court of Cook County, case number 2023 L011428, seeking $81,000 in damages arising from Lee's breaches of lease-to-purchase agreement. Cole was asserting his rights through the courts. On December 11th, 2023, 32 days after Cole's lawsuit was filed, and one day before the property was transferred, 1205 Milwaukee LLC was formed as an Illinois LLC. Kyle Jackson was listed as the registered agent. Joseph Faulkner, the man affiliated with Aspect Resolutions and connected to Jin Hee Yang, later claimed to have purchased the property through his entity. On December 12, 2023, Jin Hui Lee transferred 1205 North Milwaukee Avenue into 1205 Milwaukee LLC via a warranty deed recorded on December 15, 2023 as document number 23349064440. The stated consideration on the deed, $10. But the deed itself exposed the fraud. The transfer taxes paid on that deed were state tax of $500, county tax of $250, and city tax of $5,250. A total of $6,000 in transfer taxes. Transfer taxes in Illinois are calculated based on the actual value of the property being conveyed. Transfer taxes totaling $6,000 are calculated on a property value between $500 and $700. You cannot pay $6,000 of transfer taxes on a $10 transaction, but in Chicago you can, in Cook County you can, in the state of Illinois you can. Look, you can buy public land for $10. Well, you can lease public land for $10 for 99 years and don't even have to have an endowment. So I mean, this is Chicago. All right. Lee himself. Transfer to us $6,000, calculated property value between $500 and $700,000. You cannot pay $6,000 in transfer taxes on a $10 transaction. That stated consideration, $10 was fraudulent on its own face. Jen Lee himself will later confirm this under oath at the small claims trial case number 2023 1108836 on May 13th, 2025. Jen Lee testified in open court under direct examination that he sold 1205 North Milwaukee for $500,000, that the title company issued him a check, and that he deposited a check into his bank account. His sworn trial testimony directly contradicted the $10 deed filed in the public record. Lee admitted his signature on the lease-to-purchase agreement while claiming he never signed it, a direct logical contradiction captured by the court reporter. The warranty deed itself also acknowledged on its face the active eviction case. Subject to case number 2023-170-49999. Jen H. Lee versus Tony Cole. That means at 12:05, Milwaukee LLC took title with express actual notice of Cole's pending litigation and occupancy. A purchase with actual notice claim bona fide purchase status. These days, after the deed was recorded on December 18, 2023, Judge Goldberg dismissed that same eviction case in Cole's favor. That property was transferred while an active eviction was pending, and Cole won that eviction 3 days later. Part 5, the coordinated forefront attack. With the second eviction dismissed on December 18, 2023, and the fraudulent transfer completed 3 days earlier, the newly formed 1205 Milwaukee LLC was now positioned to act on Judge Goldberg's instructions. The instructions have been intended as a procedural mechanism for legitimate eviction claims, which followed was a coordinated assault across multiple courts. 2 new eviction cases, February 16, 2024. On February 16, 2024, exactly as Judge Goldberg had instructed, the judge instructs the people to go ahead and file this. Not their lawyer, Judge Goldberg. On February 16, 2024, exactly. Okay, yeah. Case number 2024 M1702994, targeting Cole's commercial business occupancy of the first floor and basement. Case number 2024 M1703002, targeting Cole's residential occupancy of the second floor. The plaintiff in both cases was 1205 Milwaukee LLC, acting through its claimed agent Joseph Faulkner and represented initially by attorney Christopher Acuna of law offices of Christopher Acuna. These cases were filed in Circuit Court or Cook County Court Municipal Department, First Municipal District. The Chancery Quiet Title Action, July 8, 2024. On July 8, 2024, 2025, on July 8th, 2024, 1205 Milwaukee LLC filed a third legal action, a Chancery Quiet Title case against Tony Cole. Case number 2024 CH06317 in the Chancery Division of the Circuit Court of Cook County. The Chancery case was assigned to Judge Allison C. Conlin. By filing a quiet title action, 1205 Milwaukee LLC itself placed ownership of the property into active litigation, acknowledging the effect that Cole's claim to title was substantial enough that it needed to be judicially extinguished. The moment this case was filed, ownership of 1205 North Milwaukee was contested legal question before the Chancery Division. Part 6, the Municipal Court Proceedings, Judges Stacy and Meskel. The residential eviction case 2024 M1703002 was assigned to Judge Stanley Stacy in room 409 of the municipal department. What followed this Judge Stacy's corrupt courtroom was a systematic pattern of denial that stripped Cole of every procedural tool a litigant is entitled to use. Judge Stacy denied every motion Cole filed. He denied Cole's discovery. He denied Cole's the right to subpoena and depose witnesses, including Joseph Faulkner. Before trial, despite Cole's documented need to establish the fraudulent nature of the property transfer, he struck Cole's Rule 216 request to admit as a sanction for courtroom conduct, then deemed the request admitted against Cole, turning punitive measures into a substantive weapon against the very party being punished. He denied Cole the right to file responses. He rushed the case on a compressed schedule. Throughout all of this, the Chancery case 2024 CH 06317, in which ownership of the very property at issue was actively contested, was pending before Judge Conlon, and Municipal Department Eviction Court does not have the jurisdiction to resolve ownership disputes. The Chancery Division has exclusive jurisdictions over title and equitable ownership questions. Judge Stacy lacked the authority to proceed trial while the title question was unsettled. In Chancery, he proceeded anyway. The contempt court, December 2024. They love to put a contempt court on somebody. They put a contempt court on my mama. They love to put a contempt court. On December 3, 2024, the residential eviction case went to jury trial. Cole was a pro se litigant facing the loss of his home with young children and without heat in the building. During trial proceedings, Judge Stacy found Cole in contempt of court and had him imprisoned. Cole spent 10 days in Cook County Jail while Cole was incarcerated. Judge Stacy amended the contempt order in a manner that denied Cole day for day credit for the time already served. The jury returned a verdict in favor 1205 Milwaukee LLC on the possession count. No money had been claimed in the eviction complaint. Section 6 of the eviction order expressly showed no money claimed in eviction complaint. The verdict was the possession only. After the trial, Judge Stacy entered a money judgment of $19,000 for unpaid use and occupancy, plus $321 in attorney fees, a total judgment of $19,928 on a complaint that had expressly claimed no money on a jury verdict that had awarded none. 1205 Milwaukee LLC garnished Cole's bank account based on his judgment. A possession-only eviction has been weaponized into a money judgment. The commercial eviction, Judge Meskel. The commercial eviction 2024 MI M1 702994 proceeded before a separate judge and followed the same pattern of coordinated legal aggression. Cole's commercial business space, the first floor and basement of 1205 North Milwaukee, was the subject of an eviction proceeding that contained no lease between 1205 Milwaukee LLC and Cole for that commercial unit, as no such lease has ever existed between Cole and 1205 Milwaukee LLC. The eviction of Cole from the commercial space was effectuated, that's the word, alongside the residential eviction, completing the removal of Cole's entire presence from the property. Part 7, the Chancery case. Judge Conlon rules in Cole's favor, 2024-2025. While Judge Stacy was systematically denying Cole's rights in the municipal department, Cole was fighting back in the Chancery division. In the quiet title case filed by 1205 Milwaukee LLC, case number 2024 CH 06317, Cole filed a counterclaim asserting multiple counts against the LLC. The Chancery proceedings produced a sequence of rulings that stood in stark contrast to the municipal department's treatment of Cole's claim. On May 8th, 2025, Judge Conlon issued an order denying 1205 Milwaukee's LLC motion to dismiss Cole's counterclaims, ruling in Cole's favor on 5 separate counts. Count 1, fraudulent transfer. Count 2, breach of contract. Count 3, abusive process. Count 4, declaratory judgment. Count 5, violation of the list pending statute. Yeah, let's put that. Remember that. It was it's other lady I was working with. They were talking about this. Count the list pending statute. Count two, slander of title was dismissed with prejudice, but 5 counts survived. These rulings were substantial. Judge Cohen conducted a thorough oral ruling before issuing the written order, reflecting a judicial finding that Cole's allegations if proven valid legal claims. 1205 Milwaukee LLC was ordered to answer the surviving counts on May 28th, 2025. On June 18th, 2025, Judge Cohen denied 1205's motion to reconsider, stating in the order that the motion merely rehashes arguments already made and have been previously rejected by the court in a thorough oral ruling. At the same hearing, Judge Cohen granted Cole's emergency motion for protective order, barring 1205 Milwaukee LLC from disposing Cole until written discovery was completed. The court called LLC's extension motion borderline frivolous. On June 17th, 2025, Judge Cohen issued a third ruling in Cole's favor, denying 1205 Milwaukee's LLC motion to amend its answer to add a good faith purchase for value defense. The court applied the Loyola Academy factors and blocked the amendment. The ruling was particularly significant. It prevented 1205 Milwaukee LLC from constructing a legal defense that their own sworn discovery responses had already undermined. Cole had 3 consecutive rulings in his favor from the Chancery Court. The October 2025 order and termination of the Chancery case. Despite 3 consecutive rulings in Cole's favor, Chancery case was terminated through void procedure acts on October 14th, 2025. An order was entered dismissing Cole's counterclaim without prior notice 47 days before it was legally due under the schedule and the basis of an unauthenticated document. While 1205 Milwaukee LLC had no attorney on record. This order directly contradicted the May 8th, June 18th, and July 17th rulings. Christopher Acuna, who has been counsel of record for 1205 Milwaukee LLC, abandoned the case after July 16, 2024, without filing a motion to withdraw. A new attorney, Michael Pearson, appeared without proper authorization. On November 3rd, Judge Collins struck Pearson's appearance, finding it was improper. 11 days later, on November 14th, Person, now a man whose appearance had been streaking and who had been no authority to represent 1205, filed a voluntary dismissal on behalf of the LLC. A voluntary dismissal filed by an unauthorized attorney is void. The inter-chancery was terminated through these affirmed acts, eliminating the title contest without ever resolving its merits. Part 8. We here, man, because he got court tomorrow. On March 31st, 2026, the Illinois Appellate Court, 1st District, 6th Division, issued unanimous published opinion in Peoples v. Cole 2026. Hold on. I'm going to get this check. Oh, man, let's fix it. All right. I'll get this one little chair we got. This. All right. The appellate court unanimously vacated. Okay, let me start over. On March 31st, 2026, the Illinois Appellate Court, 1st District, 6th Division, issued a unanimous published opinion in People v. Cole 2026, Illinois, appellate first 250040. The opinion was delivered by Justice Puinski, with presiding Justice C.A. Walker and Justice Hyman concurring. The state of Illinois filed no brief in defense of the contempt court. The appellate court unanimously vacated Judge Stacy's December 3rd, 2024 contempt order. The court held that Cole's statements did not present a clear and present danger to the administration of justice. The opinion documented that Cole was pro se litigant facing loss of his residence without heat and young children. Young children. And found that Cole's man, these words I gotta go back. I gotta go back to school too now. I think I gotta go back too. Utterances reflected mounting frustration with the judges as he attempted to present his case. The court found that Stacy's own conduct contribute to the confrontation. The contempt order that has sent Cole to Cook County Jail for 10 days, an order that was subsequently amended by Stacy while Cole was incarcerated, was gone. The published opinion was precedential, binding in the first district, and permanently part of the legal record. Cole had been imprisoned on a constitutionally infirm contempt order in a case where the underlying property ownership was itself contested. Cole strategically deployed this published opinion as supplemental authority in his federal court rule 60B motion and his section 2401 petitions, ensuring that every court considering this matter was aware that a sister tribunal had found judicial error in the proceedings from which these other cases arose. Part 9, the multi-forum litigation where things stood as of April 16, 2026. As of April 16, 2026, Tony Cole was engaged in active litigation across simultaneously forums. The pattern across all of them was consistent. Cole had built an evidence record opposing parties had struggled to mount coherent defenses, and multiple courts had either ruled in Cole's favor or allowed his claims to proceed. Illinois Appellate Court Chancery Appeal case number 1-25-2575. Cole filed his appellate brief, 71 pages, on March 18, 2026. The brief was accepted by the Illinois Appellate Court on March 19, 2026. The brief challenges the October 14, 2025 summary judgment, the October and November 2025 orders, and the ultimate termination of the Chancery's case. Hold on, yeah. All right. Cole filed, we did that. On March 25th, 2026, Judge House granted Cole's motion for leave to file a supplemental appendix and stating, look, this is a lawyer for real, for real. This is law. Like me, I'm still on the who, what, where, when, why, and this is how they did it. But I got to start doing this. So this is training me. The supplemental appendix placed before the appellate court sworn admissions from 1205 Milwaukee LLC and Jen Lee, including 1205 Milwaukee LLC's Rule 213 and responses verified by Faulkner showing a sworn purchase of a price of $500,000. Rule 214, production responses showing no transfer tax declaration, no title insurance, no affidavit of title, and no corporate authorization for Faulkner. Rule 216, emissions omitting no financing was used and omitting unauthorized removal of Cole's property. And Jen Lee's Rule 216, omissions confirming he was paid $20,350 as part of the lease to purchase agreement and never refunded. 1205 Milwaukee LLC filed no appearance in the appellate case. Their attorney, Christopher Acuna, did not appear. Monica Forte, counsel for the LLC in the federal court, had not filed an appearance. The appellate brief was due April 24th, 2026. With no attorney on record to file it, every sworn admission in the supplement appendix stood completely uncontradicted before the First District Appellate Court. Federal case number 124 CV 12117, Rule 60B, motion before Judge Alonzo. Okay, let me put Judge Alonzo up here because I'm really kind of heard about Judge Alonzo, but not surprised. Put my man up here so y'all know what's going on. All right, that's Judge Alonzo. All right. Cole filed a Rule 60B motion asserting fraud on the court, misrepresentation, and newly discovered evidence in federal case number 124 CV 12117. This motion was pending before Judge Alonzo, 2026. Defendant David Yanoff, acting acting through attorneys, Robert Merlot and Kimberly Blair of Wilson Elser, filed in opposition to the Rule 60B motion, DKT 178, representing that he was not involved in those proceedings, a statement directly contradicted by the public court record, which shows Yanoff's the name of attorney of record on both eviction cases has filed in Jen Lee's behalf. Monica Forte, counseled for 1201 Milwaukee LLC, and Joseph Faulkner filed a motion for extension of time to respond on April 6, 2026, the same day Yana's opposition was filed, despite having not filed appearance in the appellate course. Cole objected to Forte's extension motion. The Rule 60B motion that rests on multiple grounds of fraud and newly discovered evidence, including Faulkner's sworn testimony that he received $500,000 for the property, directly contradicting the $10 deed. Jen Lee's direct contradictions under oath regarding his signature on the lease to purchase agreement, the published appellate opinion vacating the contempt order and discovery responses establishing no legitimate transfer documentation existed. There's a whole RICO. That's a whole RICO by itself. I'm saying he got a RICO, I got a RICO, but Jessica got a RICO. Danielle, I guarantee you that area when they're zoning people out and stuff, I guarantee she's not the only one, and it shows the pattern. They got a RICO. You understand what I'm saying? But yeah, it's RICO time. Miss Jackie got a RICO. Her squad out there, they it's RICO time. It's RICO time. Monica Forte, counsel, 1205 Milwaukee LLC, and Joseph Faulkner filed a motion for extension. Oh, yeah, I said all right. A call objected to Forte's extension motion. The Rule 60 rests on multiple grounds of fraud and newly discovered evidence, including Faulkner's sworn testimony that he received $500,000 for the property, directly contradicting the $10 deed. Jim Lee's direct contradiction under oath regarding his signature on the lease to purchase agreement, the published appellate opinion vacating the contempt order, and discovery responses establishing no legitimate transfer documentation existed. SCOTUS petition. So he co-filed a petition for writ of CERTIORARI. I'll figure out. I'm gonna hold up. We all gonna want to do this too, because I am tired, but I have to get this because this is important. So I'm out of, so some of the stuff I'm gonna have to. Well, I've never seen this word. It's given, so I'm gonna have to hear how you say it. The certiorari. Okay, Sir Rari. Sir Rari. All right, so that's what that is. With the United States Supreme Court, docketed as case number 256982. Defendant's deadline to respond to the petition was April 8th, 2026. As of April 16th, 2026, no defendant has responded. Had responded at that time. Federal civil rights case 125 CV 00577 against Judge Stacy. Cole filed a separate federal Jesus. Cole filed a separate federal civil rights case against Judge Christ Stanley Stacy. Case number 125-05577, pending before Judge Chang. This case arises from Stacy's conduct in the residential eviction proceedings, the denial of discovery, the denial of subpoena rights, the contempt order, the amendment of the contempt order while Cole was incarcerated, the conversation of a possession-only verdict into unlawful money judgment, and the proceeding with trial while a possession-only verdict and an unlawful money judgment, and the proceeding with trial while the chancery title contest was pending. The published opinion in People v. Cole finding Stacy's conduct constitutionally infirm because a sworn part of the federal civil rights record. As of April 16th, 2026, the case remained pending before Judge Chang with thresholds of jurisdictional questions, including judicial immunity under consideration. Petition to vacate void judgments. On April 10th, 2026, Cole filing ready verified petitions to vacate void judgment pursuant to 735 ILCS 52-1401 in both municipal residential eviction cases and the chancery lack of subject matter jurisdiction during the pending chancery title contest, fraud on the court, fundamental due process violations. Oh yeah, you ain't gonna get no due process now. And avoid acts of unauthorized attorneys. Oh yes, all of them. absolutely unauthorized and incompetent. A hearing date of April 24th, 2026 was scheduled for the 2-1401 petition in the residential eviction case before Judge Stacy, who at that time still presided over that proceeding, while a published appellate opinion documenting his improper conduct sat in a federal civil rights docket naming him individually. I know, man, it's bad. The fraud going on and on is so sickening. It's crazy. Yeah, let me write. I gotta keep that one. Yeah, yeah. The amendment contempt order, while Cole was incarcerated, the conversion of possession only verdict into an unlawful money jump now, and the proceeding with trial, transfer title contest was pending. The published opinion in People vs. Cole finding Stacy's conduct constitutionally infirmed became a sworn part of the federal civil rights record, and as of April 26, the case remained pending before Judge Chang, with thresholds jurisdictional questions, including judicial immunity, under consideration. In April 2020, oh yeah, okay, we did that right. All right. The Chancery case, the petitions assert the judgments are voided on multiple grounds, including lack of matter jurisdiction due to the pending Chancery title case, fraud on the court, fundamental due process violations, and void acts by unauthorized attorneys. A hearing date of April 2024, 2026 was scheduled for 2-1401 petitions in the residential eviction case before Judge Stacy, who had improper judicial conduct set in federal civil rights docket naming him individually. All right. Stepping back across 8 years and dozens of court filings, the complete picture comes into focus. Jen Lee entered a lease to purchase agreement with Tony Cole in April 2018. Cole paid over $20,000 in deposits and made years of monthly payments towards ownership of a property worth $475,000. When Jin Yang, who knew about the Cole Lee purchase agreement and whose firm was affiliated with Joseph Faulkner's SPEC Resolutions Network, what followed was not a legitimate landlord tenant dispute. It was a coordinated multi year campaign across state and federal courts to strip Cole of his equity interests in the property. The campaign included two eviction cases filed without written notice to cure, both dismissed, a fraudulent federal foreclosure action designed to destroy Cole's equity interest, dismissed with prejudice, a sham LLC formed on a single day and property transferred recorded at a $10 consideration while filed instructed by the judge who never anticipated they would be used in service of fraudulent schemes. A chancery quiet title action that, when the chancery judge kept ruling against the LLC, was abandoned through unauthorized attorney conduct. A municipal court proceedings in which Cole was denied every fundamental right and imprisoned on a contempt order that was later unanimously vacated. A money judgment obtained on a possession only verdict and a bank garnishment. Against the record, Cole fought back on every front from front available to him. Four appellate and federal forums simultaneously, two 1401 petitions, sworn discovery that produce omissions, destroying the defendants, core narratives, a published appellate opinion vindicating his position. In a federal civil rights case targeting judicial conduct and a SCOTUS petition to which no defendant responded by April 26, the deadline, April 16, 2026, deadline check-in. Right. In the 2 months following the April 16, 2026, snapshot litigation intensity increased across nearly every form in which Cole is engaged. The eviction case, in particular, moved into phase entered on a judicial assignment and jurisdiction in an emergency hearing scheduled for June 22nd, 2026, which is tomorrow. The United States Supreme Court denied Cole's petition for writ on May 18th, 2026. While this case closes that particular avenue to the Supreme Court level, the underlying constitutional procedural issues remain remain live in the federal district court in Illinois appellate proceedings described below. Judge Layton's disqualification. Okay, let me bring her back up because this is who we going. This is who y'all need right here. Hold on. Where she go? There she go. All right. You back. All right. Judge Layton's disqualification order and transfer to providing Judge Sainus. May 2026, Judge Kerry Maloney Lanty granted a motion for disqualification in connection with the eviction case proceedings and orders the matter transferred back to presiding Judge Sainus. This order is significant. It established on the record that Layton herself recognized a basis to step back from the case and directed to the president judge for reassignment. Judge Murray, June 5th, 2026, hearing jurisdiction admitted and motions denied anyway. On June 5th, 2026, a hearing was held before Judge Murray in the eviction case. During that hearing, Judge Murray admitted on record that he lacked jurisdiction over the matter and then proceeded to deny Cole's pending motions regardless. A judge acknowledging an absence of jurisdiction while still ruling on the merits is a direct procedural irregularity, and he needs to be off the bench. A court without jurisdiction has no authority to act except to transfer the case. In response, Cole drafted a verified bystanders report memorializing what occurred at the June 5th hearing, preserving all contempt sworn accounts of Judge Murray's jurisdictional admission and subsequent rulings for the appellate and federal record. He might as well go to law school. He's using all them words. Verified motion for clarification of judicial assignment filed by presiding Judge Sainus. Let's see this one. Wait, I do it right? The fraud is absolutely insane. Oh, sorry. I'm trying. I gotta go back. I pressed this thing by accident. How I got all the way down? Hold on, y'all. Yes, we gotta talk about. All right. All right. On June 5th. We talked about that. Following the Murray hearing, Cole filed a verified motion for clarification of judicial assignment directed by presiding Judge Sanis. The motion seeks a definitive ruling on which judge is actually improperly assigned to hear the eviction case, given that Layton had been disqualified and the case was sent back to Sinus. On May 26th and 2, Murray nonetheless held a hearing on June 5th and admitted on the record that he lacked jurisdiction, yet ruled anyway. The assignment of the case had become procedurally unsettled. The Cole's motion asked the presiding judge to resolve that question before any substantive proceedings occurred. Verify motion to stay all substantive proceedings. On June 19th, 2026, Cole filed a verified motion to stay all substantive proceedings in the eviction case, seeking to halt further action until the judicial assignment question is resolved by a neutral, properly assigned judge. The judge is grounded in the unresolved conflict between the May 26th disqualification transfer order and Judge Murray's June 5th admission of lacking jurisdiction, followed substantial rulings. Seventh Circuit show cause order. So tomorrow, Mr. Cole is going to have an emergency hearing June 22nd at 9 a.m. in Judge Layton's courtroom, the disqualified judge. So the disqualified judge is going to go ahead. They're going to give it back to the disqualified judge, and then we're going to go from there. They do it right, and they play in our face all day. A hearing is set tomorrow for 9 a.m. Now, I put the information out there for y'all to sign in as court observers. Miss Jackie has been doing it for a while. She has a movement. Matter of fact, I went and met with their movement yesterday. And I'm going to be working on their stuff this week. I'm gonna put it out slowly because it's a lot of intense things in there that's uncomfortable. And it all happens through these courts, including this court house. And if anybody has Judge Layton, let people know. So the hearing is scheduled for tomorrow at 9 a.m. You guys can be in person. It's in courtroom 1503, or you guys can go to the courtroom email and we got that. So the report appearances is available via Zoom, and the meeting ID is 939-9214-4482. It's also on Chicago Foods Red website. Social media page. Passcode 773102. The matter on the calendar is titled Defendant Tony Cole's Emergency Motion to Transfer, Clarification Motion to Presiding Judge. Objection to June 22nd, 2026, hearing before Judge Layton, and request for hearing on three foundational pending moments before a neutral judge. The hearing is, by its own caption, a challenge to the propriety of Judge Layton hearing the matter at all, not a hearing on the underlying merits of the eviction case. The procedural posture in front of the court is therefore Layton was disqualified and case transferred to presiding Judge Sinus on May 26, 2026. Therefore, 2026, Judge Murray then held a hearing on June 5th, 2026, admitted on the record that he lacked jurisdiction and nonetheless denied Cole's motion. And Cole is now before Layton's courtroom specifically to object the hearing the matter to seek clarification of the proper judicial assignment from presiding Judge Sinus, and to request that three foundational pending motions be heard before a neutral, properly assigned judge rather than resolved on the merits at this hearing. The document does not record the outcome of the June 22nd hearing, as is not yet occurred as of writing. His closing notes, Tony's closing note, Mr. Cole's closing note, a father of two that I met today, babies. His closing notes, as of June 1st, 2026, Tony Cole remains engaged in active simultaneous litigation across municipal, chancery, appellate, federal, district, seventh court, and Illinois Supreme Court forums, arising from a single underlying scheme, the 2018 and the eviction, foreclosure, and quiet title actions that followed. The record assembled across these forums, sworn admissions, and unanimous published appellate opinion and rebutted appellate record. And now a judge's own on the record admission of lacking jurisdiction continues to grow. The question before the court remains the same. One posed at the close of April 2026, narrative, not whether Cole has a case, but which form will be the first to deliver the relief of records demand. It's a RICO. It's a RICO. These people, genuinely, they decided that they wanted to take it back. Matter of fact, let me see where bicycle. Oh. Wicker Park Alderman is Alderman Scott Wagglesback. I like Scott. I do. But also, it's some. I knew another lady who was trying to get some stuff done in his ward, and he basically turned her away. And I'm not saying he doesn't have anything to do with this because he's not brought up, but I'm gonna have to do my research, which I am. I'm going to uh, start tying everything in together. But tomorrow we need to show up for Mr. Cole because they don't want us to own anything. They don't want us to own anything, and we shouldn't have to be in a in a union. No disrespect to unions. There's some people that want to do the union thing, and there's some people that don't want to do the union thing, and they have the right to not do the union thing, and you can do the pros and cons. There's some people that say for only certain jobs a union is needed and required. I'm trying to think. What was this one guy say? The hotel workers, and I think he said another guy said it had to do with like I don't know. I gotta look it up, but yeah. So another one that he said also, but we're not being able to buy our properties. We're not able to transfer it to each other. We're not. If they want it, they want it. Of course, they want Wicker Park. Of course, they don't want no black man owning something up in Wicker Park, especially with all the new stuff coming along happening. So I'm going to see that I'm gonna go. Yeah, I'm gonna go figure out that whole situation to figure out because I know it's tied into something, but I gotta go look at these players. I gotta look at the players in the game. So and I just got this today. So I'm gonna see what happens tomorrow. And we're gonna follow this. I'm going to get those players out because we're gonna show you the pattern. So if any of you guys have Judge Jorge Alonso, and I had George Jorge Alonso, and I thought that he was a fair judge, but I will always remember his face when it was done. Um, I remember when I wasn't supposed to talk, so people couldn't. And I think I'm gonna put my transcripts out there as well. But in November 1st, 2023, I remember I just came back from Atlanta. I go to the music fest that's out there. One music fest. It's starting to fall off to me, but I just left that, and I was coming to. I mean, we had court and in person court, and my mom was up there, and she asked the judge. He said, "Can I bring my daughter up?" And he said, "Yeah, yeah, yeah." And he said, "State your name for the record," and I did. And once I did that, I went in. I broke down our whole case. I broke down the fraud. I broke down fraud and the insurance in the city when it came to the insurance. I just went in, and I remember him just like he didn't even know what to do, what to say. He said he was going to take it under advisement. Bradley Wilson, he was like, man, he just had to look at me and just like finally just nod his head like, ah man. But Judge Jorge Alonso, I remember taking I remember his face and just like 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 looking like I cannot believe that all this is on a transcript. Like I can't believe this girl came in here and broke all the corruption down. And I brought her up here because I thought she was going to be that. Please, please, Your Honor. We don't have this. We don't. We just please, Your Honor. We just want discovery. We just please, Your Honor. All that stuff. But nah, I hit him with the facts, and Miss Jessica was in there. So Miss Jessica named in the transcript too, because I said they're doing it to seniors. There's one back there, and she was back there. So this was surprising because he let me come in, but I thought that he was going to be a fair judge because he Cochran, was it Cochran? What was that alderman name? That was a police officer. And he stole that money. Hold on. Yeah, former Alderman Willie Cochran. And let me go. Let me see, because hold on. You know how they be. That's a whole nother. All right. This is Johnny Cott. Sorry. No, Willie Cochran. Sorry. That's crazy. So Willie Cochran was sentenced to 1 year in prison in 2019. A federal court sentenced former Chicago alderman Willie Cochran to 1 year in prison after pleading guilty to wire fraud. U.S. District Judge Jorge Alonzo, June 24th, sentenced former Chicago alderman Willie Cochran, 20th Ward, to 1 year plus 1 day in prison. Cochran pleaded guilty March 21st to one count of felony wire fraud after reaching a plea deal with federal prosecutors to drop 14 other charges against him. A former Chicago police officer, is a 34th Chicago alderman convicted on corruption charges since 1972 and was the third of the last four 20th aldermen to be indicted while holding office. The former councilman admitted to stealing 14,000 in charitable donations between January 2010 and April 2014 from the 20th Ward Activities Fund, a charity he created. He created this charity to benefit needy children and seniors in his South Side ward. U.S. Attorney Heather Machine argued the amount was closer to $65,000. So he stole $65,000. I'm gonna go ahead with U.S. Attorney Heather. Cochran used the stolen funds to pay for fancy dinners, Mercedes-Benz accessories, his daughter's college tuition, and gambling habit that involved frequent trips to Indiana casinos. Defense attorney Christopher T. Graham said Cochran used the money to keep his family finances in balance after his wife fell ill in 2010. According to a court made public June 13th, Cochran in 2012 allegedly met with a church pastor on the roof of an abandoned motel in his ward to ask for a loan to pay his daughter's tuition. By that time, Cochran had left the charity's account with a balance of just $7.21. Between his automatic salary and police pension, Cochran earned $137,000 a year after taxes. So this man was a gambler. He was gambling his life away, and they want to put machines, gambling machines in everywhere all on the South Side. Nah, that's not gonna happen. Um, so federal prosecutors have pushed for a sentence of up to 1.5 years in prison, while Cochran's attorney sought probation with 6 months of home incarceration. Because Cochran's sentence amounts to at least 1 day more than a full year, he will be eligible for good contact credits, which could allow the former alderman to see an early release. Early release for 1 year. 1 year for stealing all your nonprofit money and probably more money. Because what about that $2 million? Well, I don't know. I gotta see if they was getting it then, but I'm pretty sure. What about that $2 million that you was getting in the war? I know you was tearing that up in the casino. I know you took all the money that little $2 million that you get a year to take care of the money, to take care of everything that's in your ward. I know you went straight to Horseshoe because that's where you went at. Horseshoe just got to deal with them cigarettes, and I don't know them Asians. I don't know what type of say cigarettes them are. Them Asian cigarettes, they covered in coke, but he went straight with all that money. So, federal authorities initially served because if he was like this, I gotta see how long he was a alderman, and they need to do an audit. Well, he already did his time. But they need to go audit everybody else when it comes to that $2 million that they get. Federal authorities initially served Cochran with a 15-count indictment in December 2016, which included 11 counts of wire fraud, 2 counts of federal program bribery. Oh, federal program bribery. You know what? I know this is. This is it right here, because that's what the hell y'all doing. The no good Black Caucus. That's it. We go put that over here on my side. I think I found. I think I found one of the pieces to this puzzle. Let's see. This is getting good now, y'all. All right, let me send that to you before I forget. All right. I think I gotta get some of that Prevagen my mother got. All right. Cochran's prison sentence is only the latest development in a series of ongoing criminal cases. And you know, listen, they all got a year. Ed Burke, Danny Solis didn't get anything. He's a smooth snitch. I'm trying to tell you. Triple double murder Irvin is a Danny Solis, because all them drugs and drug houses that he over there got drug money. Buy her what she wants. She drug money. Cochran's prison sentence was only the other said, all right. And Roman on June 6th attempted to use persuasiveness of corruption in Chicago to make a case for a lighter sentence. According to Chicago Tribune, authorities called the argument irrational and worthy of derision. Now, Judge Alonzo, he said in one of these newspapers that the corruption in Chicago must stop. That's what made me feel like he was a good judge. Like, okay, we got somebody, but they probably gave him that line to say, because let me see if I can find. It's at my desk, because I always be like, all right. He says, oh, this is what he says. U.S. District, okay, a former Chicago City Council member has been sentenced to a year and 1 day prison after pleading guilty to corruption charges. U.S. District Judge Jorge Alonzo, sentenced 66-year-old Alderman Willie Cochran on Monday, saying he is part of a long and pathetic. I want to say this one more time now. This is Judge Jorge Alonzo says on Monday, and that was Monday back in 2019. The Monday either before, no, Monday before June 24th, 2019, or after. But anyway, it says U.S. District Judge Jorge Alonzo sentenced 66-year-old Alderman Willie Cochran on Monday, saying he is part of a long and pathetic tradition of political corruption Now, sir, are you putting yourself in that? Are you putting yourself in that? Because I thought you were a fair judge, but you were. It was terrible. You know, now I think about it. This the only reason why you even made a move in my case was because let me put you back because you were my judge too. I be trying to give these people the benefit of the doubt, but this guy right here, this guy should have he kept dismissing it. But he only dismissed it without prejudice, failure to state a claim, and I can come back. Mind you, I state the claim, did all jurisdictions. That's just y'all is what y'all do. Um, but he only made that decision because November 1st, 2023, it was heard. We received the transcripts in December. I ordered the transcripts in December. They got them together for me. And then we didn't hear from this man until in August. But the week after I came back from the Breakfast Club. And it went to motion dismissed. But you have time, you have 30 days or 21 days to respond, to do another one. And I'm like, I mean, okay, you want me to keep filing motions, or my mom to keep filing motions? Well, actually, no. We had an attorney. We had two attorneys at that time. One attorney didn't know what they was doing. Miss Leroy came in and knew exactly what she's doing, but she just came in at two at tail end. But it really didn't matter because she wrote great motions. She got me a Monell claim. She was able to get me to discovery. Um, that is in itself great. But I also got a judge that understood the US Constitution. He may have not liked some of my stuff because I heard, he had some issue. He said some things like, me calling $1 million Tony a house nigga. He said that was kind of disrespectful. And I understand that he may think that that was disrespectful, calling her that, but Your Honor, that's what she is. It was no other way to put it. I tried to be going there nicely. I'm trying to tell you, I'm about to bring them all up, so I want you to see how nice I was. Right now I'm not taking no shorts. But he kept dismissing motion to dismiss. And my thing was, that is because you were starting to work with the other attorney that my mother got that was going to sell us out. And saying like that's all they do is and trying to figure it out. And they know we got that land over there, and they trying to figure out what they could do with how can they take that land from us, but they ain't gonna be able to take the land from us. So anyway, I never got justice in his court. Now to think about it, yeah, I just thought that he was just waiting until what I was given thinking was like he was just waiting and holding it until the Fed, he already reached out to the feds, all that stuff. It was an inquiry, but nah. After I hear about Mr. Cole and nah, it's and they threw out Miss Jessica's corruption case, not Alonzo. She had another one who asked Larry Hoover them dumb questions about if he let him out, basically basically taunting him. But you threw out Ms. Jackson RICO case against the judges. Anything with judges, they're not going to do anything with them because they feel like they have immunity. You don't have immunity for fraud. You don't have immunity to commit fraud, especially when you are the person who we're supposed to go to get justice. You want us to call you Your Honor for what? For what? Now we're gonna start calling you by your first names. Horge, come on, man. Because there's no possible way that y'all are graduating. Like, let's look up. Let me see. Man. I hate it had to be him. I did, but it's good. I ain't going, my boy. So I guarantee you, I'm not the only one. Tony Coles ain't the only one. I just told somebody the other day that they going over there and that you were his judge. He said you were his judge. I was like, yeah, I think cool. And the whole time I got called Mr. Norman and tell Norman, nah, he ain't it. So he was born April 1966. And he was born in Segua La Grande, Las Villas, Cuba. He went to Loyola High School in Miami, Florida. He received his Bachelor of Arts degree in 1998. From the University of Miami, he received Juris Doctor in 1991 from George Washington University Law School. So it's some more, but in 2014, on April 5th, 2014, President Barack Obama nominated Alonzo to serve as a United States District Judge of the United States District Court for the Northern District, Illinois, the seat vacated by Judge Ronald A. Guzman, subsequently assumed senior status on November 16, 2024. He received a hearing before the United States Senate Committee on the Judiciary for September 19, 2014. And on November 20, 2014, his nomination was reported for out committed by a voice vote on April 13th. He filed a motion to invoke on a nomination on December 16th. Reed withdrew his motion on Alonzo's nomination, and the U.S. State Senate confirmed Alonzo by voice vote. He received the Judicial Commission on December 19th, 2014, and he's been selling out in the name of Cuba. And I like Cuba. I rock with Cuba because they kept Asada safe. However, I'm not okay with anybody trying to take over this country when it comes to Marxism and socialism. I have to look at the relationship with Cuba and America. I have to talk to people on both sides because I don't have an issue with Cuba. Matter of fact, I just found out when I went to go to Mayo Clinic with my mom in Minnesota, there's a little Caribbean restaurant that's not too far from the hotel that we stay at twice. And there's a lady in there that's Cuban and Jamaican Cuban food. And the owner is Cuban, but the server, she probably has some money in too. She's a Jamaican, but she's very nice. And she was telling me that the best eye doctors, if you have any issues with your eyes, and it was one other thing, but with your eyes, that they specialize in eyes in Cuba. So that, and then also, like I said, the South Shakura thing. I feel like same with Russia. People be like Putin. I just asked a Russian lady yesterday, and it's on the live. I said, "Is Putin bad?" She said, "No, man. Putin, not you. Just gotta live under these people rules in their country. Those are socialism, communism, Marxism tactics, and those things are their country. They got it working over there clearly. But you know why they got it working? Because Russia is okay with Putin making the decisions. Cuba is okay with whoever making the decisions over there. Is that the issue with when it comes to the Venezuela uh, war? We had to go get that drug dealer up out of there because he was causing havoc. Look how much havoc he done caused, dumping all them illegals from Venezuela out. We got the craziest of the crazies. He dumped them out there. The mental health asylums. He dumped out the regular jails with all the criminals and stuff. It was given like the whole situation that happened with Hurricane Katrina 2.0. Like remember how all they said that the inmates and stuff, they escaped. And I hate that they said they escaped because how did they escape? They didn't escape. They had no choice. What were they supposed to do? Just stay like drown? What? Yeah, hey, like it is what it is. They got a chance to do right. Now, you know, if they went back after that blessing of getting up out of there, then yeah. But no. So I don't really have no issue with Cuba. But we're not going to have Marxist judges. We're not going to have liberal judges stacked up uh in this court because of uh because it's a democratic city. We're just not. You got Judge Alonzo, who was appointed by Barack Obama. You got Andrea Woods, that's Miss Jackie's lawyer in federal court. She's absolutely terrible. Uh, Hold on. Let me see. Why they trying to make the Broadview 6 people heroes? All right, let's see. Judge April Perry. Okay, and she was nominated by Joe Biden. So well, I don't know, the auto pen probably nominated her. But between Biden, she just got in there November 2024. So Biden and Obama. These are Biden and Obama judges. And you are not going to get any justice. You're not going to get any justice. So we got to start coming out of numbers. We got to start coming out of numbers. We got to start telling the stories. If you're too afraid or you just don't have the energy to tell the story. See, I want to tell the story because I know I'm not crazy. Just like they thought they were going to try to make me crazy. You know what I'm saying? Try to say, oh, she crazy. Oh, she a plant. She that. Nah. You cannot knock down nobody's properties without compensating. You also cannot eminent domain or take somebody, eminent domain, but take somebody's property, the city, the government, and private property, and not compensate them. And this state has a funny way of manipulating everything, including the statute of limitations for fraud. Fraud don't have no statute of limitations, man. Just like murder don't have no statute of limitations. We're like, we're not gonna normalize people who have absolutely no idea how to run a lemonade stand. So I don't even know. So I don't even know if these people really went to these schools because I don't. There's no way in the world. Let me. What you went to Yale too? Let me see. Yale. Let me guess before I even look. Yale. So shit. Wow. Wow, man. So send me your stuff. I'm sorry. I'm listening to my mom. I'm listening to the judge. I mean the news, and I'm just hearing them in their line. It's just sad. That's why I gotta do this. This is why I gotta do this. You know, Kathy Hughes, she started in a little room, her and her son, TV1, and she got it going. And that's what I'm gonna do. I don't want no money. I want the people. I'm going to, you know, promo. If you like me to shout your businesses out, if you would like to run an ad on our newsletter things, on our newsletter, let us know. If you would like us to come and eat at your places or be at your business, or if you're willing to let us set up a live stream at your business and you explain your business and what you're doing, we're welcome. We got this notary consultant, CT Notary Consultants. They're going to be the first people. She's been trying to get me to come out there, and she's a notary. She's a trustworthy notary, and she also says that I think she says 3 to 4 affidavits contesting anything they would have to reopen it. So I don't know. Don't quote me. We're gonna go out. I'm gonna go out there and do an interview with her, and she's gonna explain. But she's a very professional notary, and we're gonna need notaries because we're gonna have to file an affidavit. Like I'm gonna need Mr. Cole to file an affidavit. Okay, if I'm gonna need Miss Jackie and her squad to get all her stuff together so we can file affidavits. But yeah, because we're gonna put if the news is not going to show the RICO and discuss these corrupt Marxist communist cartel having judges. Why y'all will not free Larry Hoover? Y'all want to ask questions about what he's doing and want to give him 200 years when y'all deserve. We would like to exchange. We would like to swap out Larry Hoover for all of y'all. But it's Rico time. It's Rico time. Okay, and I hope that they get everybody. I hope they go get everybody that has committed a crime. And yeah, a federal charge. You've got Miss Jessica fighting. She's finally, finally took a vacation after, 3 years. Scared to leave her house, scared to do this, scared to do that, scared to leave. Scared to leave the house as far as leaving to go see her she literally took a vacation to go see her grandchildren, and she's saying she's already starting to see the speech issue that they're having. So clearly everybody starts talking about the speech, right? When it comes to these kids in the beginning. So that means they're not being taught in school. So we need to understand why is that? Because they're going to need to be able to communicate. If they're not able to communicate, then they're going to be angry and frustrated and mad. And I know you like people like that too. because it's big. It's big business. But oh, it's sick. So yeah, so we will be monitoring Mr. Cole's case tomorrow, and I will be putting the key players together. And I'm gonna go to probably go to bed or take a nap. I dream of too much corruption, so it usually wakes me up, and then I start getting it together. I am supposed to get a temporary. I mean, I'm supposed to get my permanent crown tomorrow. Um. Uh. Let's see. Oh, at 4:30 p.m. So I have an appointment at Dentiology South Loop tomorrow at 4:30 for a crown. It's $475. Now, I know everybody thinks that I'm making all this money, and I'm not. I take care of my mother. I pay for uh, all the expenses that we got dealing with Chicago Fist Red. I'm trying to. I mean, I'm behind on shirts, getting shirts made and things like that because we do not have it. We are literally, it's literally. This is my job. Somebody told me, somebody called me, somebody that I used to have respect for, and the only reason why she called me was because somebody told her to call me because I was putting pressure on somebody that she knows that works for the county. But she basically wanted to say, baby, I think it's time for you to get a job. This is my job. This is my job because nobody else is going to do this. So I'm while I'm doing this, while I'm the media, I also am going to be working on this documentary because I'm tired of y'all putting everything on Donald Trump and this administration. Now, his administration may not be as strong as a machine that we're going up against because this is new to everybody, but I am going to make sure that these people's stories are told and how it all ties in with how corrupt these judges are because they are all tied in together and they're sticking together in these court systems because they know that Chicago flips red is gaining momentum, is gaining national attention. It's showing the patterns, and we have people that's affiliated with us. They're from their different counties, and they're showing the corruption in their counties. And, Pritzker has everybody on payroll, including Kwame Raoul. So they're scared. They're scared people not showing up to their events the way that, they probably would think they would turn up during this time. Tony Preckwinkle, she's gonna probably have to end up stepping down because she made that 400. She hurried up and cheated on her 400,000. Okay. Uh, my mom called me, but yeah. So stay tuned. We're gonna get this together. But yeah, I'm the media, so I'm gonna go ahead and just and get out here because we've got sexual abuse cases. We've got professors that are at prestigious universities, or people could say they're prestigious universities that are molesting their daughters and are out here teaching classes, and nobody's saying anything. Well, somebody is saying something. The mother who's trying to get custody of her daughter, but she can't get custody of her daughter. Or how about another one who's her daughter will be turning 18 in November, and they've decided to drug her and continue to keep her drug and keep this court order against It's a no contact order, so she can't see her daughter. And if she sees her daughter, if she attempts to see her daughter who has admitted to a reporter, wrote a letter, has admitted to a reporter that her father was molesting her or raping her from the ages of 4 until 13. Now she's about to be 18 soon, and they are now have drugged her up and put her in a hospital because they're trying to keep her in this hospital because she's turning 18. And once she turns 18 and once she's too drugged up and all that stuff, next thing you know, we have another child to traffic. And then it turns into Epstein Island. But it's not Epstein Island anymore. It's Pritzker Island. It's Obama Island. Okay? Pritzker, Obama, Soros. It's probably a whole much more. But we're going to say Obama. For Illinois, it's Obama, Pritzker, Preckwinkle, Brandon Johnson. And Brandon Johnson is not the person calling shots. It's Jackson Potter. So we're going to go with Jackson Potter Island. We're going to go with Pritzker Island. And we're going to go with Obama Island. And that's going to be my version of the Epstein files that you guys are so hung up on and want to talk about Donald Trump, who was the whistleblower. I'm going to connect the dots for the Obama, Pritzker, and Jackson Potter Epstein Island. Stay tuned. I hope everybody we're gonna put it out there again, but everybody needs to now. If you can get at 9 o'clock in the morning, please make sure that you do. And that's it. That's that piece, y'all. And we will see because it's Rico time.